Hello and welcome to the Insurance and Consumer Knowledge Base. Today we're breaking down your rights to security deposit funds under Florida Statute Chapter 83, Section 49. Whether you're renting your first apartment or have been renting for years, it's crucial to know your rights when it comes to security deposits. Let's get started. Florida Statute 83.49 outlines the rules for security deposits, how landlords must handle them, and the rights tenants have when it comes to their deposit money. It's all about ensuring fairness for both parties. So let's break it down step by step. First up, how landlords should handle your deposit. By law, they have three options. The landlord may place the funds in a non-interest bearing account. The deposit can be kept in a non-interest bearing account in a Florida bank. Second, the landlord may opt for an interest-bearing account. The landlord can place it in an interest-bearing account, but in that case, you're entitled to 75% of the interest earned or 5% interest per year, whichever the landlord chooses. Third, the landlord may choose to take out a surety bond with the security funds. Instead of a bank account, they can post a surety bond. But remember, this bond has to be filed with the county where the rental property is located. Whatever option your landlord chooses, they're required to inform you in writing of how the funds are maintained within 30 days of receiving your deposit. Now, what happens when you move out? Under Florida Statute 83.49, a landlord has 15 days to return your full deposit if there are no claims against it. If the landlord intends to make deductions for damages, cleaning, or unpaid rent, they must provide you with a written notice of their intention within 30 days of you vacating the property. If a tenant disagrees with any deductions, the tenant has the right to object in writing within 15 days of receiving the notice. It is critical that both landlord and tenant strictly comply with the statute and communicate with one another at designated addresses using certified mail. Sometimes, landlords may improperly withhold a portion of your deposit for normal wear and tear, or they may not return your deposit within the required time frame. If that happens, you have options. You can send a written demand for the return of your deposit, and if they still don't comply, you might consider taking legal action through small claims court. To protect yourself, always do a move-in and move-out inspection with your landlord. Document everything with photos and videos and keep a copy of all correspondence. This way, you'll have solid evidence if any disputes arise. Due to recent changes in Florida law, in a dispute over a security deposit, the prevailing party is entitled to their reasonable attorney's fees and court costs. This means that the decision to take a dispute to court must be made with care. Remember, your security deposit is your money and you have the right to get it back, subject to the landlord's right to protect their rental property. Understanding Florida Statute 83.49 can help ensure you're treated fairly. If you have any questions or need legal advice, feel free to reach out to us here at Anthony S. Hearn, PA. Don't forget to like, subscribe, and leave a comment if you found this video helpful. Thanks for watching, and we'll see you in the next video.